Imagine you're in a courtroom, and before a single piece of evidence is presented, before a single witness takes the stand, your fate has already been decided. Not by the facts of the case, but by the color of your skin. This is something that I have to take into consideration every day as a criminal defense attorney. When you go in to select a juror, you, under the Sixth Amendment, have the right to an impartial jury trial. What does that mean? It means jurors who are free of biases, jurors of your peers, people who look like you, who share experiences with you. Now, I want to talk to you a little bit about a case that I handled recently. I found myself in the courtroom defending a young black man who had assaulted a white man who had called him a very ugly racial slur. As I looked around the room, I saw 30 plus people, 30 plus potential jurors, but only a handful of them were black, maybe 5 or less. I knew in that moment that there was a real possibility that my client may have a jury that doesn't share his lived experience. And it was up to me to make sure that I selected people who could empathize, understand, and give him a fair trial. As I started to question the jurors, there was one member of the jury panel who was very outspoken, a black man who talked about his experiences of being called a racial slur. He was very vocal, he was honest, and he was forthcoming. And most importantly, he repeatedly said that he could be fair and impartial, that he could listen. The prosecutor also noticed this potential juror, so he struck that juror. When he struck that juror, I knew that I couldn't let this go. So I stood up and I challenged his strike under Batson v. Kentucky and the California Racial Justice Act. Now, Batson v. Kentucky is a Supreme Court case from 1986 that says that it is unconstitutional to strike a juror based on their race, and that was my argument. Now, unfortunately, I did not prevail. That juror was removed. But I knew that it was an important fight. You have to be vocal. You have to stand up and challenge injustice when you see it. Recently, in 2019, there was a case of Curtis Flowers. Now, Mr. Flowers was a gentleman in Mississippi, and he was tried for the same crime 6 times. How do you end up with a jury trial on the same crime 6 times? Well, every time Mr. Flowers was convicted, his defense team appealed. And they said that, look, the prosecutor is continually striking jurors, black jurors. In fact, over those 6 trials, the prosecutor struck 41 out of 42 eligible black jurors. And each time, Mr. Flowers was convicted. Finally, in 2019, the U.S. Supreme Court said enough, and they overturned Mr. Flowers' conviction, and he was set free. But think about what that means. For years, Mr. Flowers had to endure jury trial after jury trial after jury trial. He lost years of his life in prison for a crime that he was eventually set free for. Why? because the prosecutor was engineering outcomes, not seeking justice, based on race. And it's not just race. Recently, a number of cases in Alameda County, California, have been selected to be looked back upon because they were cases where the death penalty was sought, and it was found that the Alameda prosecutors were actually striking jurors that they believed, or if they knew, but just merely believed that person was Jewish. The reason for that is because they believed that a Jewish person would never agree with the death penalty because of the history of the Holocaust. Again, we see this prosecutorial overzealousness and overreaching to engineer outcomes, not seek justice. It's a violation of the Sixth Amendment. That impartial jury that you are entitled to. And the problem with this is that it erodes public trust. It sends a message to people that justice is not for everybody. Now, there are some already systemic barriers to becoming a juror in the first place. How are jurors selected? Well, if you voted, then you are in the pool of somebody who can be a juror. But who votes? Who's allowed to vote in our country? What barriers are there to voting? And who does it systematically discriminate against? Felony disenfranchisement. When somebody has a felony conviction, they may be prevented from voting. So already you have a narrow jury pool. Is that reflective of everybody? Is that an impartial jury? I don't think so. So what can we do? We have to continue to challenge discrimination. I want to talk about the California Racial Justice Act. This came out in 2020, and it is meant to enable people to challenge not just convictions and jury discrimination, but also discrimination in sentencing, in charging of people. And it was recently used in a case by a gentleman named Tommy Bonds III in San Diego. Now, Mr. Bonds is an African-American male, and he was driving his vehicle with another African-American male. And as they're going down the street, there's an officer who's facing the opposite direction, and he sees Mr. Bonds. And as Mr. Bonds' car passes him, the officer flips the U-turn, pulls him over, and as he approaches Mr. Bonds' window, Mr. Bond recognizes him as an officer that pulled him over last week. And he says to him something to the effect of, "Do you pull over white people the same way that you pull over black people?" And the officer admitted that part of the reason for stopping Mr. Bonds was because he was black. Now, Mr. Bonds' defense team presented evidence of data and had witnesses lined up who could testify to how these types of charges are unfairly and levied against African Americans. The judge did not allow that evidence. So it's frustrating, yes, when we come up against these injustices, but we have to keep bravely pushing against them. You have to stand up challenging. Even if you lose, you need to still speak up. It doesn't matter if you lose. You just keep fighting and pushing. And that's what everybody in our legal community is doing today. People at the California Innocence Project, the Cal Bar. It's important. This is a discussion that we've been having for a very long time. When I was growing up, one of my favorite books was To Kill a Mockingbird. If you don't know it, it's written by an author named Harper Lee, and it's about a small town lawyer charged with defending a falsely accused black man of assaulting a white woman. Today, To Kill a Mockingbird is one of the most banned books across the country. It's banned in libraries, it's banned in schools. Why is it banned? Because these conversations make us uncomfortable. Talking about race is uncomfortable. But it's important to have those uncomfortable discussions inside and outside of the courtroom. We need to keep advocating, keep going, even when you lose, because one day you might just win.